and 36 seconds remaining. Defendants have 30 minutes and 11 seconds remaining.
All right, what I'm going to do is give each side 40 minutes because I may ask questions and I'm going to count that on my time and not yours. So I don't want you to speed talk. You know, it's important enough. So I want to give you 40 minutes. And if I end up asking a lot more questions, I may give you more, but I want you to assume 40 minutes.
Thank you, Your Honor.
30 minutes.
So are you prepared to start now, or do you want like a 10-minute break to
If the court would indulge us, a 10-minute break would be great, but we're prepared to start now as well.
Well, I tell you what, I'll give you a 10-minute break because I want you to be organized, and we'll have enough time to complete this morning. And after conclusion of your closings, I do want to discuss with you sort of where we go from here because I have some questions generally about that. But we'll get there. But my main goal is to complete today. So we'll take a 10-minute break.
Thank you, Your Honor.
Thank you.
Court is in recess.
The recording has stopped.
After conclusion of your closing, discuss with you. Main goal. Take a 10-minute break.
Hello, you had your hand up. You have a question?
The recording has stopped.
We will resume.
This meeting is being recorded.
Court is back in session. Please come to order.
All right, counsel, come to the closing arguments, and the plaintiffs can proceed.
Thank you, Your Honor. May it please the court. On behalf of the plaintiffs, I wish to begin today by expressing our immense gratitude for having had an opportunity to present our case in court, and in so doing, to give voice to those who have too often been voiceless, and to hold accountable an agency that, at least on this particular issue, has failed to responsibly carry out its duties to protect this nation from harm. In most cases, closings are about argument, but today, Your Honor, I'm not going to argue that much because the undisputed facts in this case speak for themselves. So I begin, Your Honor, by addressing a simple yet fundamental question to this case. What is a risk? What is the standard that EPA uses to determine when a risk exists? First off, we know that TSCA commands that the EPA protect not just the general public, but susceptible subpopulations as well, including pregnant mothers and bottle-fed infants. The statute makes clear that if there is one unreasonable risk to one susceptible subpopulation, EPA must take regulatory action to protect from harm. So, what is a risk? As Dr. Thiessen explained to Your Honor, a risk exists if the human exposure level is unacceptably close to the estimated hazard level. EPA has not and does not require data demonstrating that human exposures under the condition of use cause the hazard. Now, Your Honor, this standard is not in dispute. Indeed, it is an undisputed fact in this case, undisputed fact number 16, that EPA does not require that human exposure levels exceed a known adverse effect level to make a finding of risk. But despite this, Dr. Taylor Henry admitted yesterday, in no uncertain terms, that EPA has, from day one of this litigation, used the wrong standard. They used the wrong standard of risk to assess the plaintiff's evidence. Now, each and every one, as Dr. Taylor Henry talked about yesterday, each and every one of EPA's experts in this case used a causation standard to assess the evidence, not a risk standard. Now, causation is relevant, Your Honor, to a risk finding, but it is not and never has been a prerequisite to a finding of risk. So now I'll talk about the experts that Your Honor has heard from in this case. The three experts that EPA called to the stand to discuss fluoride were not actually experts on fluoride prior to this litigation. But as you heard, Your Honor, EPA does have experts on fluoride at the agency, including Dr. Christina Thayer. Now, EPA did call Dr. Thayer as a fact witness to discuss the process of systematic review, but EPA avoided asking Dr. Thayer the obvious. They avoided asking Dr. Thayer for her assessment of the fluoride literature. It was the plaintiffs, Your Honor, not the EPA, who asked this question. And Dr. Thayer agreed that fluoride damages the brain and that the animal data supports the biological plausibility of fluoride causing neurotoxic effects in animals. So why did EPA go outside the agency and hire experts from Exponent? I submit, Your Honor, that the answer to this question is obvious and needs no further comment from me. Although plaintiffs are citizen groups and without the resources of the EPA, we brought before Your Honor world-class experts of the highest caliber. Experts who have devoted their professional lives to understanding the impact of environmental chemicals on human health. Experts who EPA has consistently relied upon for protecting this nation from harm. This includes Dr. Howard Hu. This includes Dr. Bruce Lanphier, Philippe Grandjean, Dr. Kathleen Thiessen. As you heard, Your Honor, there is no substitute for expert judgment. No matter how many thousands of pages a systematic review may be, at the end of the day, the determination of risk will always come down to expert judgment. As you have heard throughout this trial, EPA's own actions show that the agency trusts the expert judgment of plaintiffs' experts. EPA has based its regulations on the major neurotoxicants, lead and mercury, on the research of plaintiffs' experts. EPA has awarded plaintiffs' experts tens of millions of dollars in research funding. EPA contracted with Dr. Thiessen to write the agency's health assessment on fluorides. And EPA has repeatedly invited plaintiffs' experts to serve on its science advisory boards, including as recently as 2 weeks ago. By contrast, Your Honor, the record in this case is devoid of any evidence showing EPA has ever once relied on the expert judgment of the exponent scientists it retained. Not a single solitary example. So I'll talk now about the methods that plaintiffs' experts used to assess the evidence in this case. The TSCA statute commands that EPA base its decisions on the best available science, and we brought that science before Your Honor. Dr. Hu and Dr. Lanphier explained how their NIH-funded cohort studies easily satisfy EPA's definition of best available science. This is not even in dispute. Dr. Chang has admitted that these studies are the best, most rigorous studies ever done on fluoride and neurodevelopment. The methodology used by Drs. Hu and Lanphier underwent extensive vetting before they even did the studies. They underwent extensive vetting by the NIH specialist committees. And then, after they did the studies and got the results, you heard testimony that they submitted these studies to world-class leading scientific journals, who then did another round of extensive peer review. As you heard, Your Honor, the Mirek and Element studies had extensive control for potential confounders. And unlike the much cruder studies from New Zealand, the NIH studies had individual measurements of fluoride during the critical window of development, the prenatal period, just as recommended by the Farrow Statement back in 2007. In addition, the examinations were fully blinded, eliminating the potential for examiner bias, and the studies investigated so-called optimal levels of fluoride exposure that are added to drinking water here in the United States. So in addition to providing the best available science, Dr. Grandjean conducted an extensive weight of the evidence analysis in which he focused and he gave greatest weight to the best available science. And as Dr. Thayer explained on Friday, this is the approach that EPA has used since its inception to assess the risk of environmental chemicals, a weight of the evidence analysis that focuses on the best available science. Additionally, both Dr. Grandjean and Dr. Thiessen conducted the functional equivalent of a systematic review. For Dr. Grandjean, he built upon the systematic review that he had published in 2012. In addition, he fully considered the systematic review conducted by Dr. Chang in this case. And as Dr. Thayer explained on Friday, it is now a recommended practice that even EPA agrees with, that when you are doing a systematic review, you can and should build upon existing systematic reviews. Dr. Thiessen, meanwhile, conducted a risk assessment under the guidelines for neurotoxicity risk assessment, which Dr. Henry explained yesterday is the effective equivalent of a systematic review. So Your Honor, you've heard this concept at points throughout this case of fit for purpose. This is a concept that EPA specifically discusses in the risk evaluation rule. It's a concept that recognizes that a risk evaluation under TSCA is not a straitjacket. EPA recognizes that there is room for practicality, there is room for flexibility, there is room for common sense. This recognition is embodied in this concept of fit for purpose. And both Dr. Grandjean and Dr. Thiessen conducted fit for purpose assessments in this case, and there has been no demonstration to the contrary. So now, Your Honor, I will turn to the evidence. At the beginning of this case, I said that there were three key questions that need to be answered. Is there a hazard? Is there a risk? And is the risk unreasonable? The undisputed evidence in this case, we submit, demonstrates that the answer to all three of these questions is yes. First, it is undisputed that fluoride passes through the placenta and gets into the fetal brain. This means that when a pregnant mother drinks a glass of fluoridated water, the fluoride in the water will have access to the child, including the brain. It is also undisputed that unlike older children and healthy adults, a young child does not have the protection of the blood-brain barrier in utero and in early infancy. In fact, as you can see in this undisputed fact in the case, the blood-brain barrier is not fully developed until 6 months after birth. And because of this, Dr. Thayer explained on Wednesday that the EPA recognizes we need to pay special attention to chemical exposures that occur during the first 6 months of life. Yet, Your Honor, that is precisely what happens when we add fluoridation chemicals to drinking water. It is undisputed that babies who are bottle fed with fluoridated water receive the highest doses by far of any age group in the population. At the moment of their greatest vulnerability, we are exposing infants, often from the poorest and most disadvantaged communities, to a very high burden of fluoride. Now, there is no dispute in this case, Your Honor, that fluoride damages the brain. The NRC made this finding as far back as 2006. And the CDC representative in this case, Casey Hannon, who you heard from, testified that the CDC agrees with the NRC's summary of the hazard, including the NRC's summary of the neurotoxic hazard. And here you can see, Your Honor, the finding of the NRC that it is apparent that fluorides have the ability to interfere with the functions of the brain. Now, at that point, Your Honor, they were focusing on the neurochemical and neuroanatomical effects because there was not many learning and memory studies then available, but many such studies have since become available. Now, while EPA's experts in this case have criticized the methods of many of the studies, it is important to keep in mind what they do not dispute. No one came before Your Honor to say that fluoride is not a neurotoxicant. So the question of hazard really is not in dispute in this case. Here you can see testimony from Dr. Joyce Suji. I asked her, you do not dispute that neurotoxicity is a hazard of fluoride exposure, correct? And her answer was yes, at high enough levels. But what EPA didn't do is they never even attempted, never once attempted to determine, well, what are those levels? They never attempted to provide to Your Honor an estimate as to what the levels are that are causing these neurotoxic effects. The record is devoid of any EPA expert in this case making any attempt to do that. Importantly, they do not dispute that fluoride will damage the brain at a certain dose.
And my understanding is that they didn't do so because the levels that all of these studies that you're talking about show involve levels well above the exposure levels of humans in the United States. I think that's the EPA's position, right?
Well, the problem with that position, Your Honor, is even Dr. Joy Suji testified on Monday that she accepts that 20 parts per million in the water of rats is effectively the equivalent of 1.3 parts per million in the water of humans. And Your Honor, it's a well-accepted principle in EPA.
Objection, Your Honor, that misstates testimony.
That's all right. I have the evidence, so I'm not going to take objections over mischaracterizations of evidence. You can argue in your counter argument.
And Your Honor, it's as Dr. Thiessen explains in her declaration, it's absolutely standard practice for EPA when interpreting animal data to do an analysis for calculating the human equivalent dose. And so for fluoride specifically, we know that rats need more fluoride in their water to obtain the same level of fluoride in their blood. That's a toxicokinetic difference.
I understand that, but 1.3 is still well above, isn't that well above the exposure levels in the United States?
Not at all, Your Honor. And that is only, just to put this in context, that 1.3 figure, Your Honor, that's just providing you where you've done an analysis for interspecies differences. You still need to, under EPA risk assessment, you still need to provide a factor to assess, to account for human to human differences. So that going from 20 to 1.3, Your Honor, all that is doing is it's getting you, it's adjusting for interspecies differences. Interspecies differences. Then you also need to do an adjustment for human to human differences. And as we've talked about throughout this case, EPA almost always uses an adjustment of 10. So if you put the adjustment of 10 to that 1.3 figure, you're down to 0.13. So it's important when looking at animal data, we can't treat the water fluoride level in rats as equivalent to the water fluoride levels in humans. They're you need to dose the animals at substantially higher levels. And also you need to account for the fact that you have much fewer rats, much fewer animals. You know, with fluoridated water, you have 200 million people drinking it. So the EPA, Your Honor, it is standard practice for the EPA to make adjustments to the animal data to account for the differences in susceptibility between rodents and humans. And so in terms of this hazard assessment, Your Honor, we have, as you've heard throughout this case, 4 high-quality prospective cohort studies. Each of them have found significant associations between early life fluoride exposures and large reductions in IQ on the magnitude of up to 5 points when you go from 0 to 1 milligram per liter of fluoride in the urine. That's a very large effect size that rivals the effect of lead. And under EPA's guidelines for neurotoxicity risk assessment, the NIH studies are actually sufficient, Your Honor, by themselves. And clearly we have a lot of other data besides the NIH studies, but EPA's guidelines recognize that sufficient evidence of a neurotoxic hazard can be demonstrated by cohort studies which associate the chemical with a neurotoxic effect. And we certainly have that here in the fluoride database. And you heard from EPA staff scientist, Dr. Joyce Donahue from the Office of Water. She confirmed the obvious that these are well-conducted studies, but she also said that these studies warrant a reassessment of all existing fluoride standards. And now Dr. Donahue has focused her work at EPA on the dental and skeletal effects. So the neurotoxicity subject is a bit beyond what she has focused on, but she recognizes that these are high quality studies that warrant a reassessment of the current framework for regulating fluoride. So that brings us to the second question, Your Honor, is the risk question. Do fluoridation chemicals in water present a risk of this hazard? And to answer this, I think we again should look for guidance from EPA's guidelines for neurotoxicity risk assessment. And these guidelines specifically state that prospective cohort studies allow the direct estimate of risks attributed to a particular exposure. Again, allows the direct estimate of risks attributed to a particular exposure. So we have the proper studies, Your Honor, to make a finding of risk according to EPA's own guidelines. And this would be, I think, page 17, Your Honor, of the guidelines, which are in evidence as Plaintiffs Exhibit 17. And Dr. Grandjean, as you heard, he did a BMD analysis to take those prospective cohort studies and to assess the risk from those studies. And this figure, which was discussed during Dr. Grandjean's testimony, shows that pregnant women living in fluoridated areas of both the United States and Canada substantially exceed, if you just look at the mean levels, Your Honor, the average levels, these average levels substantially exceed the BMDL for a 1-point loss of IQ. And when you start to consider the upper range of exposures, which TSCA commands that we do, TSCA commands that we don't just look at the average. TSCA commands that we look at highly exposed people. If you look at the highly exposed people in fluoridated areas, you are going to see a very large differential there. And we don't just, even though the human data, there's no dispute in this case, Your Honor, that the human data is the appropriate data to derive the point of departure, to derive the reference dose, to derive your risk calculations. But that does not mean that the animal data is irrelevant. EPA has recognized that even where you have high quality human studies, it's still relevant to consider the animal data, to derive reference doses from the animal data, because if it's consistent with what the human data shows, it adds robustness and confidence to the conclusions. And as Dr. Thiessen explained, Your Honor, the animal data, when you calculate the full range of RFDs that can be justified from the data, human exposures from fluoridated water exceed the entire range, even the least protective reference dose. Dr. Thiessen, as one of her points of departure, used the Mcpherson study. And when you use the Mcpherson study as the point of departure and apply standard EPA adjustments, you get a reference dose that is well exceeded by the exposures to fluoridated water. So the animal data and the human data are consistent in indicating and showing a risk. And that brings us lastly, Your Honor, to the question of whether this risk is unreasonable. And as I noted at the beginning of this case—
Before you get to that, let me ask you about the Mcpherson study, because a lot was made by the EPA that the negative findings of the Mcpherson study post the systematic review. Why isn't that significant? That isn't, you would agree, just as they would agree, that the best studies are the Mirek and the element studies on the human side. Wouldn't you agree that the Mcpherson study is the best available evidence on the animal side?
I think it is a well done study. It has significant limitations. But I think, Your Honor, a key point here is this. They max their dose at 20 parts per million. And I asked Dr. Tsuji, shouldn't they have dosed the animals at 40 parts per million or 45 parts per million? And Dr. Tsuji said it wasn't necessary because we know you see effects up in that range. And so I think that's an important context to put it in. It had a lower dose, and there's no dispute that if you go beyond 20, in this case, there's no dispute. If you start going beyond 20 parts per million, you're seeing effects. So Mcpherson doesn't do anything to contradict that. And also—
Well, I thought Mcpherson found that at the maximum it tested, which was 20
correct
parts per million, there were no associations except for pain sensitivity.
Yes, Your Honor. At 20 parts per million in the Mcpherson study, there was an increase in pain sensitivity, which is a neurotoxic effect. So 20 ppm would be a low L for pain sensitivity. They also found that the rats swam faster. And while it's not dispositive of hyperactivity, it's certainly not a clean result. This is not a clean bill of health study. You have increase in pain sensitivity. You have rats swimming faster, so it's not a clean bill of health from the Mcpherson study.
Well, but no association with respect to the critical endpoints of learning and memory. Isn't that significant? I mean, you can't just ignore that. I know it's not a clean bill of health, but you're looking at an indicator that may not have much association or effect with respect to learning and memory, which is the key here.
Well, a few things, Your Honor, about this. First is the Mcpherson study, as with all animal studies to date, did not expose the neonates to fluoride. Okay, so there's not a single animal study as we sit here today that has ever attempted to assess the neurological effects of a critical window of development. In humans, we have many infants who are drinking fluoridated water from day one all the way through infancy. That is a critical window of development. EPA recognizes that, but we have no animal data to assess the neurological effects of that, including Mcpherson. Secondly, the Mcpherson study did not have any exposure during the first 6 days of gestation. Your Honor, that's about 1/3 of the gestational period. And the OCID guidelines say, if you can expose the rats from day 0, do it if you can. They're not saying don't. They're saying if you don't have pre-implantation loss at day 0, dose them at day 0, but Mcpherson did not do that.
But yet, exposure at day 6 is also an accepted protocol, is it not?
It is an accepted protocol, Your Honor. It's not as sensitive a protocol as you could have. So what's important here, Your Honor, is that the study is ultimately not reflecting the full range of susceptibility. So you can't take from Mcpherson, you can't have any confident conclusion that the study is capturing what we see in humans, which is full pregnancy exposures, full infancy exposures. It's not there in Mcpherson. And Your Honor, in Dr. Thiessen's risk calculations, she treated the 45 part per million concentration, which Dr. Tsuji accepts is a neurotoxic level. She treated that concentration as a lowest observed adverse effect level. And even if you treat 45 parts per million as a lowest observed adverse effect level, your reference dose is still well below human exposures.
When you apply the uncertainty factors, et cetera, et cetera?
Correct.
But you would agree that you start with the NPT, was it the NPT study that gave only low level of, I forget the term, of confidence about effect with respect to infant animals, young animals, and then you add to that Mcpherson. At least when you look at it on that basis, it appears to me that the animal studies are not very helpful.
Your Honor, I think as Dr. Thayer testified last week, she said it's a reasonable hypothesis if you're seeing learning impairments in the adult treated rats, it's a reasonable hypothesis that you would also see the learning impairments in the developmental studies. So we can take from the moderate confidence finding that the NTP had in the adult studies, you can impute from that into the developmental studies that if you had the well-conducted studies, you're going to find an effect as well.
Well, that's why I found sort of curious. Why did they have different confidence levels? I mean, based on their review of the literature, you have kind of an inverse relationship.
Right, and I think the reason that Dr. Thayer has provided is that at the time that the NTP did its review in 2016, there were very few developmental studies available, certainly few in the dose range of greatest interest. So in part, Your Honor, that was why the NTP had lower confidence in the developmental studies, as well as the issue with not controlling for litter effects, which is, as you have noted, a methodological limitation. But I don't think we can or should divorce the moderate confidence in the adult studies from our assessment of the developmental studies, it makes no biological sense that you would find learning impairments in adult animals, but not find it in the developmental studies.
So the low level of confidence is due to the nature of the number of studies and the quality of studies and the limitations, not necessarily reflective of the real world.
I believe so, Your Honor. I
Okay.
believe that's what the evidence suggests. Again, Dr. Thayer said on Wednesday that it's a reasonable hypothesis that if you're seeing the effects in the adults, you're going to see it in the fetal and neonatal exposures. And there's no dispute in this case that the developing brain is the most susceptible to environmental toxicants. It would be the a priori expectation that an animal exposed in early life will suffer greater effects than animals exposed during adulthood.
Okay.
So now to this question of unreasonable risk. And I believe the evidence, Your Honor, in this case, that you've heard from Dr. Hu, you've heard from Dr. Lanfear and Dr. Grandjean, is that the situation with fluoridated water today is analogous to the situation this nation once faced with leaded gasoline. There, as here, we have a widespread dispersal of a neurotoxicant, which results in exposure to an enormous amount of people, including the most vulnerable. It's an undisputed fact in this case that approximately 200 million people live in communities where fluoridation chemicals are added to water, and many more drink processed beverages that have been contaminated with fluoridation chemicals. To put this number in context, Your Honor, the EPA has found unreasonable risks under Section 6 where the conditions of use impact less than 2,000 people. Because of the widespread reach of fluoridation, you have millions of susceptible people being exposed on a daily basis, including 2 million pregnant mothers, over 400,000 exclusively formula-fed babies. Your Honor, these are children, and most of them are in lower income, more disadvantaged communities, children who from day one of their life, their only sustenance is infant formula. And that infant formula is reconstituted with the tap water. These are children who are being placed at a much higher risk of harm, and their interests should be considered by the EPA. Now, as we have, plaintiffs do not need to prove causation at 0.7 parts per million to prevail in this case. That's not the standard that EPA has ever used, as Dr. Henry admitted yesterday. But what makes this case so compelling, Your Honor, is that the evidence actually supports this conclusion. Dr. Grandjean explained this in his testimony. The Bradford Hill factors support a finding of causation rather than detract from it. And we have had, all risk assessments, Your Honor, have uncertainties. Every single one. I don't think there's a single risk assessment in the history of this world where you don't have some uncertainties. They're not the exception, they are the rule. And uncertainties do not preclude a finding of risk. If they did, I don't think the EPA would have made many risk determinations with the chemicals it has assessed so far under Section 6. Exponent scientists that have been in this litigation have identified, for Your Honor, a long list of possible reasons to possibly explain the findings. But I think Your Honor's exchange with Dr. Ellen Chang yesterday was notable and important. Dr. Chang was unable to identify for this court any reason why the Mirek or element studies would have, why those results would have been biased towards showing an effect. The EPA, Your Honor, has not identified for you any cogent explanation that can explain the consistent results that we see across the human studies, across multiple populations, multiple study designs, both strong and weak. Your Honor, we would submit what we submitted at the beginning of this case. The most likely explanation for the consistent results in both animal and human studies is that fluoride is a neurotoxicant that reduces IQ, including at the levels added to community water supplies in the United States. And this effect is strong enough to be detected even in studies with weak study designs. So, Your Honor, I believe the preponderance of evidence in this case has demonstrated that fluoridation chemicals present an unreasonable risk of harm. And we thank you again for giving us an opportunity to present the evidence in this case.
Thank you, Mr. Conant. I can hear from the government, please.
Thank you, Your Honor. I'll begin when you're ready.
I'm ready.
Oh,
We need to take the
can
screen
add.
down. Screen share down, please.
Oh, sorry, Your Honor.
Thank you, Your Honor. The questions presented to this court by plaintiffs, both in their opening statement and here again during closing, are overbroad and too simplistic. I'd like to clarify the actual questions before this court and explain how the evidence presented fails to provide any of the answers necessary for the court to find for plaintiffs in this litigation. But before I do that, I'd like to point out one separate and independent reason why the court must deny plaintiffs' claim. First, plaintiffs before this court do not have standing to complain of developmental neurotoxicity. While plaintiffs allege fluoride to be a neurotoxicant, the testimony offered to this court focused on one specific outcome: IQ deficits or cognitive effects in young children exposed to fluoride in utero and in infancy. Putting aside the fact that the answer of how much of the mother's internal fluoride exposure can be attributed solely to community water fluoridation, none of these plaintiffs are or were pregnant or allege future plans for pregnancy. None have infants or even small children, and none of these plaintiffs complain of a concrete, reasonable fear of cognitive deficits. Instead, they complain of self-reported headaches, which they admit have a long list of other causes. Now, concerning headaches, plaintiffs make fleeting references to the following studies. Roholm from 1939, which discusses occupationally exposed workers at an order of magnitude of 30 milligrams per day. Two case studies, Walbot from 1956 and Petroborg from 1974, with no comparison groups, no blinding of doctors, and no evidence of even a statistical association between fluoride at any dose and headaches. And finally, a study that plaintiffs' own experts call weak, a study out of India documenting self-reported headaches in exposure groups much higher than those relevant to community water fluoridation programs in the United States. Plaintiffs have not established standing based on the harm presented in their complaint, and the court must deny plaintiffs' claim and find for EPA. Now, I talked about the second reason.
Let me ask you, before you go on to that, let me ask you, I'm hearing sort of two arguments with respect to standing. One is there isn't sufficient evidence that the complained of symptoms are related or caused by common levels of fluoride exposure. So in other words, there is no harm, no causal related harm. Your second argument is that even, I take it, even if there were, the kind of harm complained of here is not the kind of harm that underpins plaintiff's case, even though they're both neurologically related, if there is such harm, and both involve the question of neurotoxicity. Do I understand that correctly?
Yes. In terms of the actual harm complained of, the constitutional standing requires a showing of, a harm that's not speculative. And what we have here is the harm complained of. The only harm, which is headaches, self-reported headaches, is speculative based on the information that's in the record now.
So that's the standard, non-speculative. I don't have to find, as a matter of fact, more likely than not, preponderance of the evidence that harm actually was causally related. I just have to find it was something above speculation for standing
That's
purposes.
right. Yes, Your Honor.
And then the second one, what about, maybe you can explain your second argument. If somebody complains of toxicity and they have stomach problems, does that preclude them from pursuing claims that are based on studies that show other health problems? Is there any law or precedent on that point? Remind me.
I'm sorry, Your Honor. That is the zone of interest argument in terms of what is within the zone of interest between a TSCA petitioner bringing their petition before the court. Under TSCA, a petitioner has the right to have their petition reviewed under Section 21. And here, the harms complained of are not supported by the harms alleged in the petition. And so plaintiffs in this matter do not come within the zone of interest of TSCA to have standing before this court.
So it is the standing question is a statutory question then, zone of interest analysis under TSCA?
Yes, Your Honor.
And remind me, I know we went over this before, but are there cases, not a lot of TSCA cases, but are there cases that are particularly instructive on this standing question? How one defines zone of interest when it's same alleged neurotoxin, same alleged idea that it's the neurological aspect of impairment, but different manifestations, different parts of the body. Is there any guidance there in the case law?
Your Honor, I believe there is, and we did cite to that case law in our summary judgment motion, as Your Honor is aware. And unfortunately, standing here right now, I am not prepared.
Yeah, all right. I may
question.
ask the parties to take a second look at that and see if there's any new case development in that. Okay, go ahead.
Yes.
Thank you.
Thank you. Your Honor, moving on to our second point here, there are 4 questions that are critical to the court's determination, and plaintiffs have failed to answer any of them. First question is neurotoxicity a hazard of community water fluoridation? Second question, what is the internal dose of persons exposed to community water fluoridation programs in the United States? The third question, is there any risk posed to persons in the United States from the practice of community water fluoridation programs? And the last question, if there is a risk, is that risk an unreasonable one? Turning to the first question, is neurotoxicity a hazard of water fluoridation? Now, in applying the definition of hazard in its most simplistic form, plaintiffs insist that modern scientific standard and the otherwise rigor required by TSCA should be relaxed because, in their view, the neurodevelopmental hazards of fluoride exposure are obvious. But glossing over the scientific process of evaluating all of the reasonably available scientific evidence in a manner suitable to understand and interpret the existing database for fluoride is plaintiff's most critical error. In other words, a hazard identification goes beyond merely identifying whether a hazard exists at any level. It requires a full understanding of the strengths, limitations, and weaknesses across each individual study and across the database as a whole. The rigor of the hazard identification process is also critical to carry forward in each subsequent component of risk assessment. Now, as Dr. Hu explained to the court, quote, when I'm serving on committees that are trying to deliberate on policy, we need to look at the whole range of epidemiological studies to understand the impacts, potential impacts on different populations. And that's also an integral part of the Bradford Hill criteria, which is also cited during this trial as an important tool for looking at all of the evidence and coming to a conclusion.
Let me ask you, hold on. You have framed it one way, the plaintiffs have framed it another way. They're taking it sort of step by step. You start with the broadest question, is it even possible that fluoride does something to the neurological system in an adverse way? Because if the answer is no, you don't even get to what levels, et cetera. Only then if the answer is yes, you then start looking at levels, for instance, to get to the ultimate question. Your framing kind of gets the ultimate question, step one. So I don't know what, in the end, I don't know what difference it is, because you don't even get to your question if there's no hazard to start with, nor do you get to your question if you find that there's not much exposure. Frankly, I'm not sure that framing this is helpful. What you've posed as number one is almost the ultimate question. You're one step away, and that's the question: is that an unreasonable risk of hazard? So I don't want to interfere with your presentation. I know you have a presentation, but I'm letting you know on my mind, the critical question to me, and I don't think it's much disputed that fluoride can be a hazard. I don't think anybody disputes that at some level. It's a hazard, a neurological hazard. The question ultimately is this one: at the community water fluoridation levels, at the 0.7 or around there, and given the way it's used and exposed and consumed by bottle, et cetera, does it present an unreasonable risk? So if you could concentrate I know you're going to get there, but that's the critical question to me.
I understand, Your Honor, and I'm hoping to pinpoint that for you over the next couple of minutes.
All right, go ahead. Thank you.
Interpretation of the database available for each possible hazard requires professional judgment by a group of experts who understand the application of scientific principles across a number of disciplines. And let me interrupt myself, Your Honor. I am going to get to your question. I'm just not going to jump there right this second unless the court would rather.
No,
okay,
no, go ahead.
Thank you. In this case, plaintiffs criticize EPA for hiring a toxicologist and an epidemiologist whose backgrounds on fluoride are not as robust as plaintiffs' own experts. But you don't have to be an expert in fluoride to speak to the application of toxicological and epidemiological principles. Using that standard, EPA would itself lack the expertise to assess the toxicity of the 80,000 chemicals substances currently in commerce. And let me stop here for a second and just speak to some of the aspersions cast by plaintiff's counsel in his closing statement. And I stop and remind everyone that TSCA commands that EPA assess all of the existing 80,000 chemicals currently in commerce. And TSCA creates a pipeline and a prioritization process for EPA to be able to do that. And what EPA said in its guidance to interested persons was that we welcome the public's help in trying to assess all of these chemicals. And what we ask from the public is that they present to us draft risk evaluations that meet the same scientific rigor that EPA would conduct under TSCA. And to assist the public in doing that, it issued guidance to interested persons. And not one of plaintiffs' experts have cited to that or even acknowledged its existence. And plaintiffs have not, Mr. Conant has not mentioned guidance to interested persons once. EPA welcomes the help of the public that meets the scientific rigor necessary to reach public policy decisions. And I'll move on. And as Dr. Hu pointed out for the court, subject matter researchers also must avoid the appearance of bias. More specifically, EPA was careful and deliberate in finding and presenting to this court an interpretation of the toxicological and epidemiological database for fluoride that has not been tainted by decades of advocacy for or against community water fluoridation. For example, plaintiffs stated in their opening that the only risk assessment in this case was produced by Dr. Thiessen. Dr. Thiessen has advocated against water fluoridation since at least 1998. And she has appeared in public meetings and debates on behalf of the Fluoride Action Network, and through her advocacy clearly has an interest in the outcome of this litigation. And for example, take plaintiff's expert Dr. Grandjean, who in 2014 wrote that fluoride is a known developmental neurotoxicant based on weak evidence, and who would rather accuse Harvard deans and the World Health Organization of misconduct than accept any scientific criticism of his own work. And rather than focus on the scientific merit of the systematic reviews completed by Dr. Suji and Dr. Chang, plaintiffs accuse them of being hired white coats who reach conclusions based on the interests of their clients. But I ask this court to consider very simply, what interest does the United States Environmental Protection Agency have in denying the existence of a hazard or a risk? As plaintiffs pointed out, EPA's mission is to protect the public health. And consistent with that mission, the truth is, if EPA found there was an unreasonable risk from community water fluoridation, it would take action to eliminate that risk. Now, more to the court's point, there are many studies that evaluate associations between fluoride in drinking water and IQ in children. No studies evaluating IQ were conducted in the United States. Generalizing the results to the US population can be difficult. Many studies were conducted in areas with fluoride drinking water concentrations that are much higher than drinking water fluoride concentrations in the United States. But that difficulty exists for other reasons too. As Dr. Hu also reminded this court, populations differ for all sorts of reasons. They differ in terms of diet, in terms of genetics, in terms of their social environment, all of which could easily lead to differences in how populations respond to neurotoxicants. And when focusing on studies with exposures in ranges typically found in the water distribution systems in the United States, studies that could be evaluated for dose response effects, those studies are inconsistent and therefore unclear. Despite there being a number of studies evaluating associations between fluoride in drinking water and IQ in children, including fluoride exposures with concentrations below 1.5 milligrams per liter, plaintiffs focus solely on the Element and Mirek cohort studies. As we explained at the beginning of this trial, the Element and Mirek cohort studies are among the best conducted human studies to date. But they are relatively recent, and there are inconsistencies within and across those studies. For example, the Element study did not find a difference by sex in IQ results, but the Mirek study did. That discrepancy remains unexplained. The Element study concluded that there was no clear association between IQ scores and maternal urinary fluoride below 0.8 milligrams per liter, but no apparent threshold was identified in the Mirek study. There was no significant association identified between blood plasma and IQ in the Element cohort, which raises further questions about what the proper measure of fluoride exposure is telling us, urine versus blood. In both cohorts, the relationships observed between IQ and maternal urinary fluoride were weak, albeit significant. Now, a hazard also includes a dose response analysis. So the hazard assessment includes both the hazard identification and the dose response. And the dose response assessment characterizes now this dose level where a potential hazard may become apparent. In other words, it answers the question before us now: at what exposure does a hazard become apparent through a manifestation of effects? The dose response assessment builds upon the systematic review that was done in the hazard ID by documenting the justifications and the limitations for the key study or studies being used to identify a dose response and to extrapolate to a protective reference dose. Now, as Dr. Thayer explained, the preferred method for calculating a reference dose is the benchmark dose approach. Dr. Thayer explained that this is because the no-L, low-L approach is constrained to the experimental doses rather than the shape of the dose response curve. Now, what Dr. Thiessen did is she derived a range of reference values based on the no-L, low-L approach as applied to certain animal data. But Dr. Thiessen's approach was critically flawed in three ways. First, as the courts already recognized, Dr. Thiessen used unreliable data to extract points of departure. The National Toxicity Program systematic review found extensive bias in the experimental animal literature. And not just because there were too few of them, but what Dr. Thayer testified to was systematic bias across the studies and indirectness in the results. And the NTP and Dr. Suji's update of the NTP review confirmed that the bias continued in the more recent studies, with the exception of NTP's Mcpherson 2018. Now, that study, of course, as you've already recognized, did not find effects on learning and memory with increased fluoride exposures at doses that exceed the general population. And to just expand a little bit on what you were talking about with Mr. Conant, Mcpherson 2018 found a NOEL at the 20 milligrams per liter. Now, this 1.3 ppm that plaintiff's counsel was referring to was actually after, in the testimony, it was actually after he had applied a number of factors to that number to get it down to 1.3. But above the 20 milligrams per liter, we don't know where the effects start to show. Now, what Dr. Suji testified to was above 20 milligrams per liter, we start to see systemic toxicity in the animals, that the animals start losing body weight. And she said she didn't know if that was because they didn't like the taste of the water or, they didn't like the taste of the food. But because there was systemic toxicity in the rats, you couldn't really tell what was going on from exposure to fluoride above that level. Now, the second reason
on Mr. Conant's statement that Dr. Thiessen derived her, I don't remember if it was point of departure or a reference dose based on the Mcpherson study. You take issue with that?
Well, problem is, Your Honor, as I remember it, what Dr. Thiessen did not identify specific studies. What Dr. Thiessen did was identify, I think it was 4 low-Ls and 2 no-Ls. And those low-Ls and no-Ls were derived from, so a narrative review included in her report and her declaration that grouped a handful of studies together. So she said at 0.5, or, at 5 milligrams per liter, these studies all found a no-L or low-L. At 20 milligrams per liter, these studies found a no-L, no-L. She wasn't specific to a study. And now what plaintiffs have, extracted throughout this trial is that they should focus on Mcpherson, and rightfully so. The problem is there's no individual interpretation of the Mcpherson study that Dr. Thiessen did. There's no justification, scientific justification offered. I'm not saying that one might not exist. I'm saying none was offered. And without having some scientific justification being offered, it's impossible to know whether the Mcpherson study really is or is not appropriate for that particular purpose.
Well, let me ask you kind of a basic question, make sure I get this. If a study doesn't show any association effect, let's see, at least with respect to memory and learning, the more direct endpoints, putting aside pain sensitivity, that would mean there is no low L, right? It's only a no L. If you only test up to a certain level and you don't see anything, you only get a no L.
That's right.
And you don't know where the low L would begin.
That's correct.
So how does one use such a study to calculate any kind of point of departure?
Well, and this is exactly the point, Your Honor, is that what you do is you have to look across all of the studies. So you have to understand, is this my key study? Why is this my key study? What are the limitations in this study? And is there anything else in the database that fills those data gaps for me? Is there anything else in the database that I could go back to? And what's the studies that fill those data gaps? What are the qualities of those studies? What are the limitations in those studies? How do I fill those data gaps? This is exactly the point as to why it's not straightforward. It's exactly the point why systematic review is necessary. You have to have an understanding of all of the studies in the database to be able to know if you have data gaps, how to close those gaps, whether you have the information or not. But more to the point here, what's so interesting about what you're saying is that NTP's 2016 systematic review identified all these gaps, right? Just what the court is talking about. It identified all these gaps. And you heard Dr. Sarah talking about, NTP said, let's design a study that tries to address all of these gaps. Let's design a study the best we can to get towards those low dose levels that we're so interested in and try to correct for the bias and indirectness we're seeing across the database. And NTP did that, and they did that with people who have expertise in animal neurotoxicity. And they went out and they designed the study the best they could, a suite of studies, have we heard? I think the number might have been 9. And based on that study, they found no effects. And so the question becomes, quite honestly, is this study might be the best study, but is it appropriate for deriving an RFD? And we need to understand the entire database to be able to answer that question.
And so the APA's position, I understand it, is that yes, in order to derive a point of departure, you have to kind of look at all the studies to determine where some of the low L's and no L's are, but you give different weight to different studies in making that determination depending on their degree of reliability.
That's right. You have to understand. Yep.
And that in this case, the most reliable standout would be the Mcpherson study. The other studies, which were rated by the NTP as sort of low confidence.
Well, I think, Your Honor, even that question remains unanswered. I think the question is, if like Dr. Suji testified to, it is the best existing study right now. But the question is it enough? Is it enough to close those data gaps? Is it enough to get it to tell us, if there's a NOEL, what is the level where we actually start to see exposures?
Let me ask you, the ratings of the NTP, as I recall, there were 4 classifications, from like very low or none, or the very bottom. I think it was very low or something, then low, and then moderate, and then high, or something like that.
I think that's right, Your Honor.
All right. So with respect to the infant studies, it wasn't the very bottom. It was low. So it wasn't worthless. I mean, those studies had some value. It just was low. It was like the 3rd out of 4 categories. Right?
Well, it's another great point you're making, Your Honor, because I think that what NTP said and what EPA would say is all you need is one study to get above that very low threshold. One well-designed study, I think, is what we would say, what EPA would say, and NTP to get above that low threshold. So if you're going to say, and remember, Dr. Thayer explained for us, if you're going to say that there's no evidence whatsoever, you would have to be able to prove that there's nothing out there that shows a potential risk.
Where would I find the criteria that the NTP uses? Is it in the report where they define what those are?
Yes, Your Honor. It is, and it's in evidence. And I can't believe I hope I get this right. I can't believe I might know. It's EPA's trial exhibit 518, which is the OHAT handbook. OHAT is the NTP program. And in that handbook for systematic review, I do believe that they talk about the different levels of evidence. And I would expect that it is true that also in EPA exhibit 553, which is the NTP 2016 report itself, I'm sure that they also describe the levels of evidence in there.
And what about the dialogue I had with Mr. Conant about that it seems counterintuitive that you would find an effect in adult rats, but not in infant rats, given the developmental stage, the window, and all that. Is that explained simply by the quality of the research and the availability of the research, and not that it is likely there are effects on adults but none in infants? And in fact, that it's a compound question, but the fact that there's a higher level, moderate level of confidence with respect to effect on adult rats, wouldn't that imply that if you had the same quality of studies, you would find effect on infant rats? I mean, how could it be? How could it not be?
If I could clarify the court's question, just so I make sure I understand what you're asking.
I guess what I'm asking is the fact that the NTP 2016 study found a moderate level of, I guess, confidence, whatever it is, in the adult rat studies, animal studies. From that, shouldn't one infer that there's likely an impact on infant rats? And the only reason why that the NTP rated it as low level of confidence was there just wasn't very many good studies out there. Not that it doesn't exist, the phenomenon doesn't exist, it's just the quality of studies weren't very good.
Well, let me take a step back. There's a couple of things. I think it's factually inaccurate to say that the reason why NTP found a low level of evidence in animals exposed during development was just because there was a low number of studies. I don't believe that to be factually correct. I mean, I think Chris Thayer said the problem was in the developmental studies specific was indirectness. They didn't know whether changes in the animal's motor and sensory functions were causing the delay in cognitive effects. And it was too indirect and they couldn't make that cause there. But, I think that.
Well, also many were hampered by the not taking into account the litter effect, right? That affected a number of those studies.
Well, yes. And that was a bias, right? That was a different reason. That was the bias, the systematic bias across all the studies that showed the lack of blinding. But there was also the second factor, which was indirectness. And so, I think the question is, can't we assume, that if there's moderate level for adults, that there would be a moderate level for infants? Yeah. And I think, quite honestly, Your Honor, the answer is if we could assume that, then NTP would have assumed that. But they didn't. They very specifically made the distinction, and they were careful about that. And I'm not a toxicologist, but I think, if I could just take this question and take this discussion kind of to the next level, because I think the bigger issue is, I don't think anyone could dispute that there's a hazard at some level. But the question now becomes, for everyone, is that level anywhere relevant to community water fluoridations and exposure in the United States? And this is where we start. This is where we're in the second piece of this hazard assessment, which is the dose response. And this is what we use the systematic review for so specifically here, which is now we need to be able to see, is there any indication that the dose is the hazardous dose is anywhere near what's being exposed? And we have to look at these studies. And what Your Honor, I think Your Honor is correctly focused on Mcpherson, but I think even Mcpherson still leaves questions. And more to the point, nobody's gone in. What Dr. Thiessen offered was a scientifically or methodologically inferior process to the BMD process, right? So I think what would happen is you would have some experts, people who have expertise in rat neurotoxicity and toxidynamics and all of those sorts of things. They would go into Mcpherson and try to fit the Mcpherson, study with their BMD models. And they might do that. Or they might decide through systematic review that the human evidence is more relevant, because what we have heard testimony on is if there's an abundance of human evidence, the human evidence is more relevant. And you can rely on the animal database where you need to try to close some of those gaps. But given the human database that we have for fluoride, it's more relevant. And I think methodologically more appropriate to look at the human studies and start there in terms of trying to
why
find.
don't we I agree. Why don't we focus on the human studies, if you could?
Sure. And I'll, if it's okay with Your Honor, I'd like to keep going through. I'm definitely going to get there. Okay. If you would bear with me.
Okay.
So Dr. Grandjean also derived a range of reference values using a BMD analysis applied to Bashash 2017 and Green 2019. But Dr. Grandjean's testimony vacillated between being able to conduct a BMD calculation on the back of an envelope to having to rely on a world expert on benchmark dose to do the calculation for him. But nevertheless, the most telling thing about the level of confidence one could have in the offered BMD was Dr. Grandjean's testimony that once he can gain access to the raw data from both the Element and Mirek study, he can, quote, calculate the real benchmark dose. But even more fatal than that is the inability for anyone to critically assess or replicate the calculations due to the glaring lack of transparency in both his declaration and live testimony. And these critical flaws carry forward through the remainder of Dr. Grandjean's analysis and further discredits the reliability of his ultimate conclusions. And I'm going to go into those studies now. I guess the next question then before the court is we need to understand what is the internal dose of persons exposed to community water fluoridation programs in the United States. Now, plaintiffs submit that maternal urinary fluoride is the proper metric for measuring fetal exposure. And the court heard a lot of testimony comparing neurotoxic effects of lead exposure to the potential neurotoxic effects of fluoride exposure. But to compare the well and long established impact of lead on IQ and studies that have quantified blood-lead IQ relationships over multiple populations to the more limited evidence base for fluoride is just simply not justified. The relationship between
can I back up just for a second here, going back to Dr. Grandjean and lack of transparency? Yes. My recollection is that he had to digitize from the scatter points, right? All points of data.
For one study that was published at the time he conducted his report.
Right. Did the EPA ever attempt to replicate that on its own and have any of its experts try to do that and see whether they came out with different results?
We did not, Your Honor.
Did the EPA have access one way or another through discovery to those data points, the raw numbers that fit into the BMD calculation, not the back of the envelope, but the ones he had his colleague perform? Was there any discovery on that?
So there's no raw data available. The Bashash 2017 study clearly was published before expert discovery started. And so there was access to Bashash 2017. But from EPA's perspective, EPA never got to the dose response assessment because we never got past the hazard assessment question.
I'm asking you a question. I'm asking in discovery. You had a
I
chance
understand,
to
Your Honor.
Yeah. And
I understand.
You had a chance to depose. You had a chance to subpoena or request documents. Did you ever request that Dr. Grandjean produce the digital results of that scatter plot so you could run it without having to digitize it yourself? Have your experts run it and see whether his calculations or his associates' calculations were verifiable or not?
We did not. And the Green 2017 study, Your Honor, I'm sorry, 2019 study, that was not published. It was published towards the end of expert discovery. It was actually published the night before Dr. Henry was deposed. And so we were in the middle of expert discovery at that point. And Dr. Grandjean, when his second supplemental expert report was based on the manuscript, not the published version. And so so that study wasn't even published while we were still going through expert discovery.
Well, but I mean, you've had time. I guess my point is, if you're making the transparency point, I think the obvious comeback to that is that what he did, his methodology and his source of information were transparent through his declaration, and provided ample opportunity for subpoenaing documents and conducting cross-examination, conducting a parallel calculation to impeach his calculation. So I'm not as concerned about transparency in that as to that particular issue. But go on.
Well, and then that, let me just respond. I mean, that's what I was getting to about when you say that we should have or maybe we should have requested the information and run the calculations ourselves. I mean, that's what I was trying to get at just a couple minutes ago when I was trying to say EPA never got there, because they never get to the dose response, because without the systematic review, you don't, if, quite frankly, if EPA would have run the data it would have given credibility to using that study in the first place. And the point is, there's really no credibility for using that study without having the systematic review, without knowing whether that is the key study. There's no point in doing that exercise.
Well,
because
there's a point in litigation. There's a point in litigation if you know the other side is going to rely on somebody's study and analysis to derive a critical component of the risk evaluation. You have the opportunity to examine that.
But they
without making any concession. You're saying, well, we didn't want to make a concession that these studies were reliable. You don't have to. You just all you need to do is say his studies are hogwash or his calculation was wrong. Here's the error. Here's what we came up with. That doesn't admit anything. In any event, let's move on. Let's go on. The next point.
The relationship between blood lead and IQ decrements has been studied for many years, and it has a very large body of data underlying the blood lead IQ relationship. For example, there have been numerous cohort studies of population groups from cities across the United States, as well as in other Western countries. And while the relationship between the urine fluoride and IQ are recently described by Bashash 2017 and Green 2019 using small non-US populations at one point in time, the generalizability to even the full Mexican and Canadian populations are unknown, but unquestionably do not approach the generalizability of evidence base for blood lead and IQ relationships in the US population over time. Now, currently, the variability and uncertainty associated with the urine fluoride IQ relationship is largely unknown due to so few studies being available. And Bashash 2017 and Green 2019 actually highlight the large variability associated with the use of urine as a measure of fluoride exposure. For example, measures of fluoride in urine is a short-term measurement of exposure that is highly variable due to a number of factors, including the time of sampling, hydration state, and the methods used to correct for hydration. Additionally, measures of fluoride in urine are also subject to confounding, which is why we need more than these two cohorts to understand the true nature and the uncertainty in using urine as an exposure metric. And Dr. Lanphier and Dr. Hu highlighted this variability in their testimony. First, Dr. Lanphier testified that it's hard to predict water concentrations from urinary fluoride alone, and that other sources factor into the concentration observed in urine. Dr. Hu testified that whether the source of fluoride exposure is from salt or water could affect the concentration of fluoride observed in a spot urine sample. And now that's important, Your Honor, because we know that Mexico fluoridates their salt, not their water. Now, given all of the uncertainty and variability, we simply do not know enough about the urine fluoride IQ relationship to determine whether the Mirek and element cohorts provide the best available methodology for estimating the internal dose from exposure to community water fluoridation. And as a result, this question remains unanswered. I'm going to move on to the next question, which is there any risk posed to persons in the United States from the practice of community water fluoridation? And despite the current variability and uncertainty in using maternal urinary fluorides as a reliable exposure metric in the Mirek and element populations, to the Green study concentrations was, quote, ultimately the most important consideration, Dr. Grandjean testified that he never even compared the final published version, peer-reviewed published version of the study with the manuscript that he relied on in forming his opinion that the association reported in the US. And he testified that the association reported in the UCSF study was weak, statistically non-significant, and not even indicative of true maternal urine fluoride levels of the California women studied. Now, hazy BMD lines and weak associations simply do not rise to the level of best available science for the purpose of justifying EPA regulation.
All right, hold on.
Let
me ask you some questions right there. You criticize his reliance on the draft and not the final study. Remind me, the final published version came out with different numbers?
Your Honor, I don't have that information standing here right now, but the concern is that Dr. Grandjean couldn't tell us that either. So the problem is he offered an opinion in this case. It was based on a manuscript, an unpublished manuscript that he disclosed to EPA 5 days before his deposition in this case. And no, he never even confirmed. He offered a declaration based on the published version of that report, even though that was published after expert discovery was closed. And he couldn't testify that he compared those two studies. So we don't know, standing here right now, whether there were any differences in the manuscript or the published version.
Well, that may go to his credibility and what you might call lack of rigor. But the material question seems to me, the substantive question is, did he rely on an erroneous number? Was it corrected in final, which is something you would have access to and could have crossed him on? It would be useful to know if in fact he relied on a number that was materially changed as a result of between going from draft to final, and he relied on a number that was outdated. That would be significant. But
well, 2 points, Your Honor. I did cross-examine him on that. I did ask him if he compared it, and he said no, he didn't compare it. So there's that point. But does the EPA have information to show that that final number was different? I don't have that information standing here right now.
All right, then let me ask you. Actually, I'm trying to remember now the testimony about the weak correlation. The correlation was between what? What was the correlation that was weak?
The correlation between maternal urinary fluoride concentrations and community water. I believe it was and the community water measurements that they were comparing that to.
Community water measurements of their, I'm trying to remember now, of their home.
There was, I believe it was, if I don't have the number wrong, it was somewhere, I think it was 51 women who were giving birth in San Francisco. They were not from San Francisco, but they were in San Francisco overnight. San Francisco fluoridates water. So they had drank water in San Francisco and had given a urine sample. And this study was comparing the urine samples from just those 51 women from all parts of the Bay Area against community water fluoridation in San Francisco. So it wasn't even indicative of where these women actually lived. It was indicative of just comparing their maternal urinary fluoride to, that's not true, actually. They did compare, they compared their maternal urinary fluoride to the reported community water concentrations of where they lived, where they reported they lived. So they did do that. They did.
And some came from non-fluoridated areas. Is that right?
Well, I don't think we know that information. What Dr. Grandjean, I believe what he testified though that it wasn't indicative. The water fluoride concentrations of those women wasn't indicative of where they lived because they were in San Francisco the night before and had been drinking water in San Francisco, which we know does fluoridate water.
Does the EPA have information to suggest that the median levels found and the distribution of the levels found in these 51 women were not accurate, were not reflective of other fluoridated communities?
Well, I think it's, the point is that their urine samples, as Dr. Lanfear and Dr. Hu testified, your urine sample is going to be indicative of, your most recent intake. So the idea is their most recent intake was in San Francisco. And so you're comparing, their most recent intake in San Francisco to their community water fluoride concentrations in their homes. And so that's the logical leap in understanding that it's not indicative because urine samples is such a short-term measurement.
Well, short-term measurement, and the most recent exposure was in San Francisco. It seemed to me the question is whether San Francisco community fluoridation levels are consistent with what we see throughout the country. Is there anything unique about San Francisco fluoridation level?
Not that I understand, but I think the court is raising the right question: is can we assume, or should we assume, that these 51 women represent the entire United States? And I think quite clearly the answer to that is no. I mean, I believe there was testimony by Dr. Lamphere and Dr. Hu that even the element, Mexico City itself is not indicative of all of Mexico in terms of intake or maternal urinary fluoride. And the same in Canada. I mean, the study in Canada, the Mirek cohort, is a big cohort, and it covered a number of cities. But I think there was testimony that even those maternal urinary fluoride concentrations are specific to that population and not to all of Canada. Now, can you do that? Maybe, but the question is, should you? And I think, the question of saying, should you use one study out of California with 51 women who are about to give birth and in a city drinking water that's different than the water that they're intaking at home, should you use that as a way to generalize maternal urinary fluoride concentrations across the United States? And
did the EPA introduce any evidence to suggest that was not a good representative? In other words, if there are sort of national standards and the distribution from the EPA exposure, that big table, right, from 2019, is there anything, when you compare the San Francisco concentrations, and I don't know if they're at 0.7 or what, whether that puts them outside that range? Where does San Francisco fall in that big national study?
Well, I have an answer for you, but I'm not sure it's in evidence. And so,
well, that's something, if it was outside, that would have been useful information, because you could have impeached the value of the UCSF study in terms of its generalization and its reliance.
Your Honor, I think
Dr. Grandjean's reliance on that by showing that he relied on a particular study that was not representative or was outside the mainstream of the study that the EPA did.
Well,
I didn't hear that.
Well, first, I think that Grandjean impeached himself by suggesting that it was a weak correlation and that it wasn't indicative. In fact, what Dr. Grandjean said when we pointed out it was a weak correlation, what he says is, well, I just cited to the UCSF study because it seemed important to EPA. What I was using was the World Health Organization's, measurement. So, I think that the study has been impeached. And, we talked about, you heard testimony from the CDC about N. Haynes. And N. Haynes is the entity in the government that takes all of these measurements. And it takes the measurement across the entire US population. And there's no evidence in this trial by anyone as to whether those, and for what years those urinary fluoride concentrations exist, if they exist, for what years, and what those numbers are. But surely the N. Haynes data would be a much more appropriate and reasonable measurement than 51 pregnant women in San Francisco in terms of generalizing that information to the United States.
The N. Haynes is the intake measurement, the amount, the concentration of fluoride in community water, right?
No, the N. Haynes actually does go out and tests biomeasurements of fluoride, of a lot of things, but it does do it for fluoride as well.
Urinary measurements?
So there's some dispute about whether N. Haynes actually has reported the data yet. And again, that's why I want to be very, very careful here. But it is, urinary fluoride is something that the N. Haynes could do for the entire country.
But what the table we saw was fluoridation levels of community water, wasn't it? Did I get that
That's
wrong?
right. No, that was EPA's exposure factors handbook, which was a systematic review of the available evidence on intake, on water intake, across different subpopulations and at different percentiles. Now that intake that exposure is different from dose. So the intake is the exposure and the urinary fluoride is the internal dose.
Okay. All right, go ahead.
We did hear a lot of testimony from Dr. Grandjean that on his chart, he included a hazy BMD line. And I submit that a hazy BMD line and weak associations do not rise to the level of best available science for the purposes of justifying EPA regulation. Now, the final question before the court is, if there is a risk, is the risk an unreasonable one? And plaintiffs argue that the purported risk of community water fluoridation is unreasonable, in part on the potential extent and magnitude of exposure to fluoridation chemicals. And it is true that these are factors EPA has said it would consider in making a finding of unreasonable risk. But before EPA or the court ever gets to these considerations, plaintiffs must first set forth a scientifically defensible basis to conclude that any persons are at risk of neurotoxic harm as a result of exposure to community water fluoridation. In this forum, that means that plaintiffs need to show that it's more likely than not that fluoride causes neurodevelopmental harm at a dose experienced from exposure to community water fluoridation programs. The fact that a purported risk relates to a large population is not a basis to relax otherwise applicable scientific standards in evaluating the evidence of that purported risk. Now, I want to back up for a moment and verify that, yes, in fact, I said plaintiffs need to show that it's more likely than not that fluoride causes neurodevelopmental harm. And I have no wish nor the skill to embark upon a philosophical discussion of the meaning of causation. The cause of an illness may be imminent and direct, or it may be remote and indirect, underlying the observed association. But the aim of hazard assessment is to understand the factors of the association before deciding that the most likely interpretation of the association is causation.
Where does this, what is the source of the more likely than not causation? Where does that come from?
Well, more likely than not is the preponderance of the evidence standard.
And where does that come from? What regulation, what statute?
The preponderance of the evidence is the standard under Section 21 for the court's review of whether there's unreasonable risk.
All right. And what about causation? Where is causation? Where's that? What's the statutory or regulatory basis of that?
Well, as I was explaining, causation is a factor in considering, causation is considered as part of the risk assessment process, meaning if you have an association, the whole point of risk assessment and looking at these associations is to determine what's your confidence in the association so that the more likely interpretation of that is there as actual cause. So this reflects the confidence in the database itself. What I'm getting at is causation itself is not a standard. Causation is not a standard. It's not a standard here, but causation is a consideration that has to be part of any unreasonable risk determination, either by EPA or the court. So in other words—
Well, there's two ways causation, I understand, comes into this. One is whether there's a biological or mechanistic plausibility, because if there isn't, then you would give less weight to it. But if there is, that sort of maybe conforms or corroborates a statistical association. Number two, causation is statistically, I would think, is something where the association is so strong and the confounders are so confidently eliminated that you can't come to any other conclusion that there's a causal relationship. It is a degree. It is at one end of the spectrum of association. Yes. So I understand that, but if the standard is a lower standard under TSCA, it's association, not causation. I understand if you prove causation, then a fortiori, you've shown association, but not vice versa.
I don't think I 100% agree with you, Your Honor. It's exactly the point I'm trying to make, is that it's a matter of degree. But nowhere is TSCA, the only standard provided in TSCA is unreasonable risk. TSCA doesn't talk about causation or association. It talks about unreasonable risk. And then it says How you go about finding unreasonable risk is you do a risk evaluation, and it defines a risk evaluation, and it defines a risk evaluation of all of the steps of risk assessment plus a risk determination. And what I'm suggesting is that causation, the Bradford Hill factors, those are considerations in the risk assessment process. So there is, you're correct, no statutory place in TSCA that requires causation, and there's no statutory place that talks about association either. What's required under TSCA to make a finding of unreasonable risk is a risk evaluation. It's a risk assessment that's included as part of that process, and as part of the risk assessment process is a consideration of causation. You heard Dr. Thayer testify that the Bradford Hill criteria are built into systematic review. Systematic review is the functional application of the words the Bradford Hill criteria say. That's what Dr. Thayer describes systematic review. And so there can be no real true dispute that causation as a factor is part of risk assessment, risk evaluation, and important to finding, making a finding of unreasonable risk under TSCA.
Can you find, here's the bottom line question. Can, under Section 21 of TSCA, can the court find an unreasonable risk without finding causation?
Yes.
But causation is a factor. But it is possible to find an unreasonable risk even without causation.
Yes. And I'll tell you, the risk evaluation process is about interpreting the confidence in the association. It's about determining the degree of causation. That's what risk evaluation is about.
Well, confidence of association, and one end of confidence, the very strong end, would be causation. Once you've got there, you've pretty much eliminated, at least in the analysis, confounding problems, imprecision problems, enough to find causation. I mean, to me, association is a spectrum. There's very weak association, no association. There's moderate, there's very strong association. And the more and more that statistical strength is, the closer you get to causation. Is that construct wrong, that spectrum concept?
I think that's right. I think we're defining causation in some concrete terms here. And I think in the process of risk evaluation, in the process of risk assessment, the court was right to say that causation is a matter of degree. That at the end of the day, you have the risk assessment process, but then you have this separate risk determination step. And in that risk determination step, there has to be consideration of, is the likely interpretation of this observed association I'm seeing, is the likely interpretation of that reach some level of causation? And if you can't say that you can't interpret the association anywhere near causation, then you have a lot of uncertainty, and you can't find a finding of unreasonable risk. You can't regulate on something you don't think is a true association, on something you don't think is really causing the observed association. And in that sense, it's not a concrete term. It is a level of degree, and we think it's absolutely relevant to the risk evaluation process.
And have there been prior, I think we talked about this, or you all talked about this in the trial, have there been prior EPA risk evaluations that found an unreasonable risk, but not necessarily causation?
Your Honor, there are no, let me back up. There is one published risk evaluation under the amended TSCA. There are no others. Now, I believe it is correct to say that the one published risk determination under amended TSCA is for 1BP. And that 1BP, the basis of the agency's unreasonable risk finding was based on methodologies applied before the statute was amended. So on pre-amendments, EPA conducted a risk assessment for 1BP. When the statute was amended, there was a provision in the statute that allowed EPA to grandfather in whatever risk assessments it had ongoing at the time. And so 1BP, the risk assessment for 1BP was finished, and the risk assessment was published. And since that time, this statute since that time, EPA has not yet published one final risk determination.
Okay, the one BP, did it find causation expressly?
I'm sorry, it's methylene chloride, not 1BP. So that was the one that was issued. So I apologize for that.
Okay.
And there is a 6A rule. So I imagine I have to assume that they did find unreasonable risk, but I do not know if it was based on causation, and we're trying to get that information for the court right now.
And prior to that, prior to TSCA, or TSCA amendment, were EPA risk evaluations, were there any that found unreasonable risk without express finding causation?
So, Your Honor, let me back up and answer your previous question. So for the MC determination that we were just talking about, EPA found that it caused acute toxicity, it caused death. So EPA did make a finding that it caused death for that determination. Prior to, the difference between, one of the big differences between amended TSCA and post amendments was that there was no risk evaluation requirement in the post amendments. And so that process is very different. And that post amendment.
You mean pre-amendment?
Thank you. Yes, thank you. The pre-amendments did not have a risk evaluation requirement. And so in the pre-amendments, I believe it's accurate to say that the TSCA program relied on just the existing agency guidance at the time to conduct risk assessments under the policies and procedures available and current at the agency.
And did those existing agency guidance require causation in order to regulate?
I would say, I think I can fairly say no.
So your position is that the amendments to TSCA, is it your position that amendments to TSCA effectuated a change in that standard?
I'm not saying, what I'm suggesting is that causation is very relevant to a risk determination. I'm saying that if you're considering unreasonable risk, the statute is very flexible in terms of what you should be considering. And I'm suggesting that making a finding of unreasonable risk based on a weak association or an association that doesn't rise anywhere near the level of causation would be inappropriate. I'm not suggesting that a risk determination or that amended TSCA requires causation. I'm not suggesting that.
But what you are suggesting, it has to reach the level of, quote, anywhere near causation in order to constitute an unreasonable risk.
Well,
I'm just using your words.
I appreciate that. Thank you. And again, I can't, EPA hasn't completed any risk assessments. It said it's going to be very flexible about how it determines risk. And so one of these issues is uncertainty and variability in the data. That's a key issue that EPA has expressly said that it would consider. And the more uncertainty and variability you have in the data, the harder it is to have confidence in the association itself.
That I understand. You may not even get to a sufficient association if you have too much uncertainty and variability. But that's irrespective of causation.
I think that's the question, right? I'm suggesting that that's what I'm suggesting is there's no hard and fast definition for causation here. What I'm suggesting is I feel as if plaintiffs have conflated this causation conversation. EPA has produced, and we asked our experts to produce an evaluation to measure the association, to measure our confidence in the association. And that process of measuring confidence in the association, we've used the term causation to describe that process in measuring confidence. And I think that the reason why we've done that is because the process of risk assessment is the process of determining, how likely is it that the proper interpretation here is that exposure or this chemical is causing that effect. I mean, that is the definition of hazard assessment, is answering the
that come
question.
from? Where does that come from?
Well, if I apologize, I'm trying to think if it's in evidence or not. If you can just give me one moment on that.
I'm particularly interested if there's a statute or regulation that says that. I'm not sure what you mean by evidence. You're saying hazard assessment by definition requires causation.
Yes, Your Honor. So I'm just going to grab Dr. Henry's trial declaration. So starting at paragraphs 99 all the way through paragraphs 105, Dr. Henry describes hazard assessment. And I'll start at paragraph 100. Hazard assessment, also called effects assessments in some EPA guidance documents, identifies the type of adverse health or environmental effects or hazards that can be caused by exposure to the chemical substance in question and characterizes the quality and weight of evidence supporting this identification. She goes on. The principles of
let me stop you right there. Paragraph 100 says that can be caused, not is caused, or more likely than not caused. She just says can be caused.
Well, I mean, I maintain that, the risk assessment process is about determining our confidence in the association, and that is specifically relevant to causation. And I think, as Dr. Thayer testified to, the Bradford Hill criteria and the criteria for causation are built into the systematic review. They are the systematic review is the functional application of the Bradford Hill criteria, which is the criteria for causation. And that's what we're looking at. And that's when NTP defines, low, moderate, or high, it's looking at the level of evidence towards causation. I mean, that's what systematic review is. It's a level of evidence of how likely it is that the chemical substance you're assessing can cause an effect. And that's what systematic review is. And I maintain that that's what risk assessment is. And if you can go through the risk assessment process, you can go through that whole process, right? You could do it on weak data. But the question at the end of the day is the data I relied on strong enough to regulate on? That's the question. So, when we're looking at, and this is what we get to, this is where we have to separate kind of risk assessment, pre-amendment, and post-amendments, where you're looking at the risk determination step, where the risk determination step gives the agency the ability to consider those things now, to consider the uncertainties, to consider all of these factors that ultimately lead to that question of causation as a matter of degree.
All right, go ahead. Why don't you finish up?
The court heard a lot about the applicable scientific standards and methodologies for supporting evidence-based decision-making in environmental public health. Dr. Chris Thayer, who's been responsible for leading not one, but 2 United States government program offices recognized around the globe for advancing state of the science for supporting evidence-based decisions, making evidence-based decisions in environmental public health, laid out for the court the most current and relevant methodology for addressing hazard and risk questions. Systematic review is a methodically detailed process designed to ensure objectivity, transparency, clarity, reproducibility, and utility for risk managers. Dr. Thayer explained the meticulous process of taking a deep dive into each individual study and teasing out the trends, related to a number of different biases domains within a group of specialized experts across different scientific disciplines, so that they can ensure that they are identifying the best possible study or studies to use in subsequent steps in the risk assessment, including the dose response assessment. Now, plaintiffs concede, as they must, that they did not present to the court a systematic review, or in other words, they admit that the information presented to the court does not represent the current state of the science to support regulatory decision-making. Instead, they ask the court to believe that systematic review puts form over substance and slows the protection of human health. But just important as protecting the public health is EPA's responsibility to preserve and promote scientific integrity in regulatory decision-making. In fact, the EPA's ability to pursue its mission to protect public health and the environment depends upon the public's ability to trust the science and the scientific process that informs public policy decisions. And just as this court cannot make the best decision unless it has confidence in the integrity of the science on which it relies, risk assessment and systematic review are the compasses guiding EPA's health and environmental protections decisions, but more specifically, and more relevant here, TSCA demands that those processes be followed prior to granting EPA authority for regulating chemical substances in commerce. Plaintiffs want to sweep these issues of scientific integrity away. They say the court can make a decision under Section 21 of TSCA divorced of the considerations required by EPA under Section 6. And putting aside that question as a matter of law, I ask the court as a matter of practicality to consider that if it does make a finding of unreasonable risk, EPA would be required to regulate. Yes, in some manner, but nonetheless, regulate the American people solely on the basis of what's been presented to this court. And as you heard from Dr. Henry, EPA's regulations must be supported through the demonstration of clear and transparent scientific judgment, carry forward through each component of a risk assessment process. And in the absence of an integrated risk characterization that explains all of the key findings, assumptions, limitations, and uncertainties in the database, EPA simply does not have the information necessary to reach an informed policy decision concerning the practice of community water fluoridation in the United States. And I will close, Your Honor, by noting that in 2015, the National Toxicity Program began the process of evaluating the evidence that exposure to fluoride is associated with neural development or cognitive effects. This review was initiated in part in a response to a nomination from the Fluoride Action Network, a plaintiff in this case. And maybe the Fluoride Action Network didn't like NTP's initial findings of a low level of evidence to support neural developmental effects in animals exposed to fluoride during development. But because before the NTP could undertake a similar evaluation of the human evidence necessary to reach just a hazard conclusion, the Fluoride Action Network and other plaintiffs petitioned EPA to ban the practice of water fluoridation, otherwise ignoring all of the other risk assessment components and jumping directly to unreasonable risk. And they did so without Bashash 2017 or Mcpherson 18 or Green 2019 in tow, which brings us to the present day. And throughout this Zoom trial, with a handful of lawyers and experts arguing and interpreting rapidly advancing science, in fact, simultaneous with this trial, the NTP, in consultation with the National Academies of Sciences, is completing a systematic review, integrating the available animal and human data to reach hazard conclusions in a manner that is consistent with the state of the science for reaching such conclusions. And Dr. Hu and Dr. Lamphere, they continue their research to close the data gaps and answer outstanding questions. But despite all of that, plaintiffs are trying to convince the court that fluoride's neurotoxicity is so obvious that none of this needs to be done. And in the backdrop of the NTP yet to complete even a hazard conclusion, plaintiffs are asking this court to conclude that it's more likely than not that the practice of community water fluoridation poses an unreasonable risk of neurotoxic harm. EPA asks the court to let the science advance, to first, verify urine as an appropriate measure of exposure. Second, apply the science to specific U.S. populations. Third, conduct additional analysis to better describe and understand the variability and uncertainty in the database. And fourth, to reproduce the validity of exposure measurements within different Western populations. There is simply too much uncertainty and variability in the existing database for the court to make a finding of unreasonable risk. The court should deny plaintiff's claim and fine for EPA. Thank you, Your Honor.
Let me ask you, thank you, Reporter. Let me ask you the NTP review. That's the one where there was the draft monograph that had been circulated,
Yes, Your Honor.
and that had been out for review and comment. Is that right?
Yes, Your Honor. The draft was published in late October. It was put out. It was. Let me put it this way. It was not published. It was put out for peer review. It went to a National Academies of Science peer review committee. The National Academies of Science posted and published the draft NTP monograph on its website in preparation for the public meeting. Public meeting happened in mid-November, I believe. And the National Academies of Science finished their peer review and sent the draft back to NTP with a number of comments. And that, I believe, that was February, that the peer review, the NAS actually published a peer review report that described its peer review, and it sent that report back to NTP, and NTP has yet to complete or publish a its final hazard conclusions on fluoride, specifically addressing this issue that's before the court.
The National Academy published its peer review comments in February,
Yes, Your Honor.
and then now the last step is awaiting NTP finalization after receiving those reports.
Yes, Your Honor.
And your chart looked like you were forecasting a fall 2020 completion. Do you have any information?
I have not gotten any information since we've been in the COVID-19. I mean, I don't know.
Okay. All right. Since Mr. Conant has the burden, I'm going to give him 5 minutes of rebuttal if you want a short rebuttal. If you have anything to add or comments.
Thank you, Your Honor. First, with respect to hypersensitivity, I would just repeat that the National Research Council in both 2006 and 2009 found that the case reports, which included double-blind studies, were credible, and the symptoms reported in these studies included headaches. I would also note that counsel in their PowerPoint slide cited, I think, 4 studies, which is certainly not the extent of the studies that the NRC relied upon. In terms of generalizability, Your Honor, as I think has been sort of endemic to EPA's positions in this case, EPA seems to have a double standard. It says we can't rely on studies from Canada and Mexico, and yet its own experts rely on studies from New Zealand, Canada, and apparently they wanted to rely on a study from Spain. I don't recall any discussion from EPA as to whether those studies are generalizable to the US population. With respect to animal data, I would reiterate and emphasize, I think, a very central fact in this case. Dr. Christina Thayer, who is the one scientist at EPA with the greatest knowledge base on the neurotoxicity literature, she testified in this case that the animal data supports the biological plausibility of fluoride causing neurotoxic effects in human beings. That is a critical fact, and it's a critical fact when we are assessing the epidemiological data. With respect to the Mcpherson study, counsel misspoke and said that Dr. Thiessen did not rely on the Mcpherson study specifically for a point of departure. That is false. Dr. Thiessen specifically relied on the Mcpherson study for one of her points of departure. So counsel misspoke.
Remind me, how do you derive a point of departure where there is no low L?
Well, it's a situation. Well, first off, the EPA uses NOELs, Your Honor, all the time for its points of departure for risk assessment. It's a standard point of departure to use. Here, because the Mcpherson study did not use the higher doses, and Dr. Suji testified that she didn't think they needed to use the higher doses. Here, as counsel, I think, correctly stated, you can look to the broader literature, look to the dose response that you see in the broader literature, and say, we're clearly seeing effects above 20 ppm. Mcpherson didn't find an effect on learning and memory at 20 ppm. It's a reasonable point to use for the assessment. I would agree.
Okay, so you look at broader literature in order to give it time. You can't just look at the one study with no effect.
Yes. For instance, Your Honor, if you only had one animal study on fluoride neurotox, that was it, and you didn't find any effect at all, then you're not going to be doing a risk. You're not going to be creating using that as a point of departure. It's only when you have a credible basis that this compound causes neurotoxicity that you would be using Mcpherson in this way, because we clearly have animal data showing neurotoxic effects. Now, I would also note in terms of the concentration that Mcpherson used, the rats, remember, Your Honor, only had mild fluorosis. And in this country, in fluoridated areas, you have about 40% of children who have at least mild fluorosis. I think that's an important fact to keep in mind when considering the relevance to the United States population. With respect to, counsel made a point about the number of studies on lead and IQ that were available to the EPA in 2008 when EPA issued the lead standard. Counsel put on the screen a reference to 6,000 studies. But if Your Honor may remember, they asked Dr. Lanphier about that on the stand. Dr. Lanphier made a very important point. He said, yes, there was a ton of studies on lead, but at that time, there were only 3 epidemiological studies on lead and IQ at concentrations below 10 micrograms per deciliter. So at the concentrations of interest at that time, there were not many epidemiological studies available. Now, with respect to the UCSF study, first off, we don't need to guess. We don't need to speculate. There's no material change between the draft manuscript and the final paper. No material change whatsoever. No need to speculate. The data is there. Now, counsel mentioned a weak correlation between water fluoride and urine fluoride in that relatively small cohort. Correct, there was a weak correlation. There's a very plausible reason for that. The fact of the matter is, if you're leaving your home, say a non-fluoridated community, and you're going to San Francisco for a day or two, you're drinking some fluoridated water during that day or two, that's going to obscure, Your Honor, the relationship between your home water fluoride level and your urine fluoride level. But the key fact of that study, Your Honor, is when you look at the urine fluoride range in the women who came from the fluoridated areas, it's squarely in the range that we see in Canada. And as Dr. Grandjean explained, it is biologically impossible for the average urinary fluoride levels among women who actually drink fluoridated water to be below the BMDL. The BMDL is about 0.15. If you're drinking fluoridated water, we already well know that the concentrations in the urine are going to be right around, give or take, the level in the water.
Is there any evidence about the level of fluoridation in San Francisco water compared to the NHANES table?
Yes, the level in San Francisco is 0.7 parts per million. Now, and the Haines is an important point, Your Honor. So I want to make one thing emphatically clear, because the record in this case is uncontested and undisputed on this point. The Centers for Disease Control has never, ever, ever issued or published any urinary fluoride data for any population, for any age group. EPA knows that. We deposed the CDC in this case. They said they've never published any urinary fluoride data. What they did have, Your Honor, is in 2015 and 16, the CDC collected some urinary fluoride data, but they have not yet released it. And in the population that they collected the urinary fluoride data it was for children 3 to 19. There is counsel, EPA right now today could not say truthfully that the CDC has ever collected urinary fluoride data for pregnant women in this country. And
what about my question about the level of, I take it your position is that the 0.7 parts per million is common throughout the country.
Absolutely, Your Honor. There are still, interestingly, there are still some areas where they haven't yet adjusted downwards to meet the recommendation from 2015, where the CDC and others recommended we lower the levels from upwards of 1.2 ppm to down to 0.7. Some communities are lagging behind on that, but absolutely the target concentration today is 0.7. I would also note that the CDC allows water municipalities to have a range of up to about 1 part per million, because they recognize it's somewhat difficult to keep it precisely at 0.7 on any given day. Now, with respect to, council mentioned that one of the risk evaluations that EPA did, I think it was for methylene chloride, found causation. I think she mentioned death and acute toxicity. I strongly suspect, and I believe the record will show, that's causation at a very high level. I think your Honor's question was about causation under the conditions of use. I don't believe under the conditions of use in that risk evaluation, human beings were dying. So I think that we need to distinguish what we're referring to there with causation. And Your Honor, that's all the comments I have. I appreciate your opportunity to provide a rebuttal.
All right, thank you. All right, here's what I want to talk to the parties about. Appreciate your closings and your presentations. I had previously determined that the evidence in this case, given de novo review, given the comments in the legislative history, were not confined to the administrative record. And obviously, we've gone well beyond the administrative record because so much has changed since that record, that petition was filed with the EPA. And I think that timeline that Ms. Carfura showed shows that. There have been 2 significant series of studies, prospective cohort studies, which everybody agrees is the best methodology. Everybody agrees that these were rigorous studies. I think everybody agrees that these studies would be part of the best available scientific evidence. You also have the UCSF study, which provides one, and I know it's disputed, but one potential link or brick in the generalizability of the Canadian and the Mexico studies. These are significant developments. I had also ruled initially that I wasn't going to extend a trial date and allow discovery into the NTP then draft monograph. There was a motion initially, I think, by the government to not allow its inclusion. I can't remember which way it went. To exclude it, right?
No, to include it, but to have expert discovery on its interpretation.
Right, but there was later, I think, a motion in limine after that. In any event, the parties came to an agreement not to introduce it for whatever reason. So it's fine. So it hasn't come in. But the court is aware that this is a significant study. It's coming from the NTP, and they're using methodology, it appears, and I haven't seen the peer review. I haven't seen the National Academy of Science peer review comments, but it is obviously an important piece of evidence, whether you agree with it or not, how reliable ultimately it is. And that seems to be forthcoming perhaps any day. But the main consideration I have is I've sat here now for 2 weeks listening to the expert testimony, reading the documents, and it occurs to me more than ever now, having actually experienced and heard the evidence, that what is before this court is an entirely different body of evidence, not entirely, but a substantially different body of evidence that was presented to the EPA. It also occurs to me that, pursuant to the colloquy I had with Ms. Carfura, that the EPA appears to have applied a standard of causation, which, from my read of TSCA, is not accurate. Is not a proper application. It's not the proper standard. I understand that it's part of the spectrum and it informs the consideration, but it appears that the EPA operated on a standard of causation and not allowing for association, perhaps even a strong association or sufficiently strong association to find unreasonable risk that might be short of an actual finding of more likely than not causation. All this counsels to me, to pause for a moment and say, why are we here? Doesn't it make sense to have the agency take a second look? Take a look. Now that the evidence has been produced by both sides, and maybe it can be refined, and it's going to be informed hopefully soon by the NTP and maybe some other things. There's the pooled study that Dr. Lamphere is hoping to I don't know how long that's going to be. You've got the Spain study that is not in published form, not been peer reviewed yet, but who knows? I don't know how long that takes. But the point is, what was presented to the EPA was a very, very different record than what I have now. And although the Section 21 of TSCA confers upon the court the power to act in the face of inaction by the EPA if the proper findings are made, as you can see, this is an enormous task. It is a task that this court may well have to undertake if necessary. What I have to say, it seems to me that even if there's no formal doctrine of administrative exhaustion, and I don't see anything in the TSCA that requires it, other than having petition and going through the process, I don't know if it contemplates a situation where the record before the court under a Section 21 petition is very, very different and has evolved substantially differently than what was presented. And so my question to the parties is whether it makes sense for you to discuss possibilities of either an amended petition and reconsideration by the EPA, or if necessary, starting a new petition since it's a fairly rapid process, and to hold my decision and my adjudication of this in abeyance and give the agency a chance to relook, and hopefully relook at it under the proper standard of review. I know I'm springing this on you, so I don't expect you to, and I know you're going to have some initial reactions. Mr. Conant is distrustful of the EPA, et cetera, so I could predict that. But I ask you to, you can comment now, but I'd like you to think about that and whether there is a way to allow the agency, and really the urging of the court, to take a second look, because there's serious evidence here. There's no doubt that these two studies from Canada and Mexico raise serious questions, and the witness, Dr. Donahue, I guess, right, said I know it's only one line out of a deposition, but her comment about, well, it may be an appropriate time to reassess and revise, relook at this whole question. And I and this is coming from somebody who knows her stuff.
Your Honor, if I may.
Yeah.
I don't want to harp on this difference in statutes, but Joyce Donahue works in the Office of Water, and that is a different program under a different statute, and that's All
right. Well, I'm not relying just on Joyce Donahue.
I understand.
I cite her because she expresses sentiment that it seems so obvious.
I understand, and you should know that the Safe Drinking Water Act requires EPA to review their standards every 6 years. So I believe, I'm sure my colleagues will correct me if I'm wrong, but I believe the last one was 2016. So the Office of Water under EPA, under the Safe Drinking Water Act, is required to review their statutory standards in 2022. So that's the Safe Drinking Water Act. But I anticipated this question, Your Honor, and it's something that I've been talking to my client about, not just over the past couple of days. It's something actually Mr. Conant and I have been discussing since January to find out if there was a place to go here. And I just want to express to the court, I very much appreciate, the issue with fluoride that we're dealing with here. But above and beyond that, the agency has other interests here because amended TSCA is a brand new statute. This is a case of first impression, and there's a lot of implications in terms of implementing the statute, quite frankly. So above and beyond fluoride, there's there's many more considerations that the agency has to take here. And so that's a concern. And the other issue is that in our conversations with Mr. Conant, through, beginning probably early January, and also, excuse me, very early on, the problem is that we have not been able to identify a statutory mechanism that would suggest the approach the court is suggesting. In other words,
Well, you mean a reconsideration or whatever? There's no such thing as a petition for rehearing before the agency?
No, not within, if the agency denies the petition, there's 90 days to file and get judicial review. So there's no mechanism in the statute for that at this time.
Well, there's no other such mechanism. You can always file a new petition, right? There's nothing prohibiting that. You could file a new petition. I don't know what the doctrines of res judicata and collateral estoppel are in the administrative field, but this would be based on wholly different, new evidence. So worst comes to worst, if people can't find a way to do it more efficiently, I mean, that's an alternative too. And frankly, we do have the issue of standing here. I mean, the last thing I want to do is go through a detailed analysis into the substance of this, and if I find standing and get to the merits of this one way or the other, and then, have the work completely thrown out because of standing, seems to me that's another reason to consider a petition. Frankly, I don't know, seems to me that it's obvious who would have standing, where there wouldn't be a question. And so in the end, it could save a lot of heartache and a lot of headache if we do kind of a reboot. But it's not just a reboot for that purpose. It's because there's been evolving scientific evidence in the last 3 years now, 4 years, almost 4 years.
Your Honor, certainly appreciate the court's guidance and input on this, and we certainly want to give this due consideration. I'm certainly happy to speak with counsel and see where we may have potential agreements. I would, as you picked up on, plaintiffs have been frustrated over the years with EPA's. It really, Your Honor, has dragged its feet for a long, long time. NRC concluded in 2006 that the current safety standard is outdated and unsafe, and EPA still has not done anything to lower that standard. So we are in a situation where the EPA has sort of made a political decision not to do anything. And that is precisely why plaintiffs brought this petition in the first place.
Well, I understand your feelings about that. I'm not going to say one way or the other whether that has validity or not. But what's different is not only the state of the scientific evidence, but the posture of this case. We have a live case. I have a Section 21 case right now. And if I, as a matter of case management, say, all right, I'm going to take this under submission for now, but I want you all to do, go back to the administrative process, that doesn't mean this case goes away. I still have this case. I could rule on this case. And I'm sure the EPA would be aware of that. As well as the plaintiff would be aware that if I rule on this case, I might not come out in your favor. I mean, you all don't know which way I'm going to come out at this point. And so just as a matter of procedural context, we would still be in litigation. I'm not dismissing this case. I would probably just take it under submission or put a pause on it, stay maybe, and say, go back to the EPA through one mechanism or another. Now, if that doesn't resolve it, I guess you're back here again. Whether it's on a new petition or we just revive this, and there's all sorts of procedural things that we could do. But my main point is that really, I would hope that the agency would take a serious look, apply the proper standard, and look at this new evidence. And there's going to be more stuff coming out in the next couple months. I don't know which way it's going to go, but I do think that makes sense given the seriousness and the consequential impact of whatever we do, whatever the EPA does. I understand it's just a threshold showing. It would kick in rulemaking if the plaintiffs prevail, so it doesn't end the inquiry, but it's still a significant issue on all sides, for reasons stated by both. And I'm aware that EPA's, there's a lot of pressure, the prioritization of the chemicals and everything else, and that's why Section 21 allowed some breathing space when you get into rulemaking and all that. But, it's not like we're starting fresh. There are people, it's not like they don't know anything about this issue. It's not like coming out of the blue. The record in this case is now public. The studies, all this stuff, the body of evidence is there. It's growing, but I mean, it's not like we're starting from nowhere. So that's why it occurred to me.
Your Honor, this is Chris Nidell. I just have a question related to your recommendation.
Yeah.
Would you envision some limited discovery on any new additional studies or available information that comes out?
You mean if it came back to court?
So for example, if NTP came out with their assessment, their final assessment, and for some of the reasons that have been stated, plaintiffs were skeptical of some of the bases or some of those conclusions, or just wanted to get discovery from NTP on how that evaluation was done and what was considered, would that be a tool that might be available to us?
All right, what's government's response to that?
Your Honor, I'm not insensitive to any of this. So, the problem is that there are very specific statutory limitations on the authority that EPA has here. And there are very specific limitations on the authority that the court has here. And regardless of whether we have more discovery and we have more trial, at the end of the day, unless plaintiffs can produce to this court a risk evaluation that meets the scientific standards and the rigors of that required under TSCA, the agency does not have the resources or the ability to conduct a risk evaluation for fluoride outside of the prioritization process. And there's some very specific legal limitations that we think drive that.
Well, are you saying that if somebody, let's say somebody else filed a petition, are you saying that is going to be denied for lack of resources, that the EPA could not comply with the statute and render, there'd be inaction, is what you're telling me, the 90 days would run?
I'm not suggesting that at all. And I want to try to be, very clear. If EPA only has 90 days to review a petition under the statute, that's the legal limitation. They have 90 days. And the position we've taken in this litigation is that, and this is consistent with the guidance that we've put out, that EPA has put out to the public, which is we welcome the public's help in helping EPA evaluate these chemicals. But there's specific guidance in that interested persons should follow that guidance and produce to EPA an evaluation that meets the same rigor and statutory standards required by Congress or required by the statute. And that would be necessary. That would be the level of evidence necessary for EPA to be able to reach a determination of unreasonable risk within the 90 days that it has to review a petition. In other words, The risk evaluation rule and Section 6B gives EPA up to 3.5 years to do an evaluation. There's no way EPA could do a risk evaluation within the 90 days it would take for someone that they have to review a petition. And so the position of the agency has been and continues to be, give us the information we need that meets the statutory standards so that we can make a risk determination within the 90 days provided under Section 21. And so we would never, in any case, predetermine any decision on a petition or any other decision EPA might make. They don't make any predeterminations. They have to be able to, within the statutory limitations, be able to make their finding based on the information that's submitted in the petition.
So you're saying that if the petition, let's say a new petition or amended petition, whatever you want to call it, is filed, and in the view of the EPA, procedurally, it doesn't meet the rigors of a risk evaluation with all the elements, and I guess you're suggesting systematic review being part of that. I assume that's what you're saying.
So I'm trying to be very, clear. The position of EPA is that the petition has to meet the best available science and weight of the scientific evidence requirements of the statute. EPA believes and has codified a definition for weight of the scientific evidence. And so I'm not saying that a petition has to do that, that the EPA might require that. And what Dr. Henry actually testified to the other day is that all the right pieces would have to be in all the right places for EPA to be able to have the information it needed to make the decision within 90 days. And that doesn't mean that it has to follow exactly EPA's procedure, but it means that all the right information has to be in all the right places.
Well, all right. That is something that you have the advantage of being able to meet and confer in advance, knowing the record as it is. You can have a meet and confer to see if any new petition or amended petition, whatever it's called, is sufficient to trigger a meaningful substantive review. True, it has to be done within 90 days. I guess there's no way to, there's no statutory way to extend that. Is that correct?
That's correct.
Right.
That's one of the limitations
but
that
rather than being hit by a petition out of the blue, you all are in this case, you're all communicating. You certainly can have some communication about what it takes to trigger a meaningful substantive review, because I think that's what we're all after, not just some procedural ruling by the EPA saying, well, we don't really have time to deal with this because you didn't do it in this form, and therefore we're going to deny that. That's not going to be very helpful. That's not what I'm hoping for. I'm hoping for a substantive review, and I think, you know, you can meet and confer and see if you can come up with something that I won't call it pre-clearance, but something sort of pre-cleared by the EPA, so you know it's not going to just be kicked out on procedural grounds. It'll be, whatever the form is, sufficient to trigger substantive review. I mean, it seems to me that you know, the better minds in the legal field, including yours, all of you, should be able to figure that out.
Your Honor, on behalf of plaintiffs, I am happy to speak with EPA to discuss some of these possibilities. I would note for the court a concern that I have just thinking about this now. And that is that, as you may imagine, this has been a pretty, for citizen groups, has been, I think, fair to say, a massive undertaking. We have spent now about 4 years. And the concern I have is if we, you know, the idea of starting a new petition, the resources and time involved with that is something that may be prohibitive for these citizen groups. So, you know, we certainly believe we have presented sufficient evidence to demonstrate a risk under the proper standard under Section 6. So that is our That's my main concern, Your Honor, as I think through this out loud. So I just want to just put that out there for the court. That's my main concern thinking about this. Now, another thing, thinking out loud here, I'm sure, is to the extent that this was to be stayed in some degree, some fashion, we would certainly want to see EPA do something now to help begin trying to protect the public. For example, starting to warn people, pregnant mothers, about the risk that we now see here in the science. Because EPA has done absolutely nothing. And, it's, as we saw in the Bradford Hill statement, Your Honor, we can't ignore the evidence that we have in front of us. And for so long, the EPA has done nothing. They've done nothing to protect the public from the risks. And we could do a risk evaluation that lasts another 4 years. And in the meantime, you have hundreds of millions of people who are experiencing this risk. And the statute, the Toxic Substances Control Act, was designed for the precise purpose of not having to expose people for risks, just, till you wait for the final proof, to the final causation. Congress amended
But it does require, before regulatory action is mandated, a finding of unreasonable risk, even if not causation. And so what you're asking for is almost, I don't know if you're asking for the court to order something, or you're saying that's something you'd like the EPA to do.
It's yes, Your Honor, it's what gives me apprehension about any process that would conceivably extend this by potentially years, is that we are back to the situation where we have a clearly identifiable.
Well, I don't know about years. I didn't say this case is going away. This case has been tried. I have the record, and if I have to, I'll rule on it. But I'm thinking months, not years, because for you to recraft, and I understand the resource issue, but frankly, you've devoted so many resources into this case, and you've got a lot there. You may have to do a little, you have to do some more. I don't know how much more, but if you can get it in a form that is sufficient to trigger substantive review, that once you do file it, there's a 90-day clock on it, and and then we'll see where we're at. So however long it takes you to recraft, meet and confer, and then recraft something, file it, it's a matter of months, not years. And if it comes back here in whatever form it comes back, we've already tried this case, so you wouldn't be starting from scratch. It's not like starting all over again. I wouldn't think. Now, if you file a new action based on the new petition, we'd have to figure out whether we consolidate I'm not going to forecast every procedural nuance, but I don't anticipate that I would be sitting on this for years if there's no resolution.
Understood, Your Honor.
Go ahead.
I was just going to ask for any guidance from the court in terms of, I'm happy to begin a meet and confer process immediately with Ms. Carfora and DOJ counsel to just start discussing this, right? Any guidance from the court as to whether, in terms of meeting back up with the court to discuss this further, and kind of that sort of time frame?
Yeah, my plan would be to ask you to meet and confer, to see if you can figure out a procedural, mechanism and a process that would effectuate what I'm talking about. Then I'd like to have a further status conference to see where we're at. And I don't know how many, I leave it to you, whether that's 3 weeks out, 2 weeks, 4 weeks, 5 weeks, whatever you think, 6 weeks, 2 months.
I would, for plaintiff's position, it would be the earlier. So we would, if it's 2 weeks or 3 weeks, that would probably be our.
We request at least 30 days, Your Honor.
All right, well, I think that's a fair request because it's a big ask. I understand that. And there are limitations on both sides. It's resource issues, frankly, on both sides. You get EPA with all its priorities, statutory priorities, and everything that's going on. You got citizen plaintiffs with limited resources, and so I understand that. And yet, trying to think of what the most coherent way to approach this overall problem is, and it just seems to me that makes sense. So why don't Angie, why don't we set a comeback status conference in 30 days? And then if I can ask you, just send me a joint statement, a brief update as to where you are, 5 days before.
Will do, Your Honor.
Okay.
And Your Honor, in terms of post-trial briefing with respect to findings of fact or briefing on standing, what is the court's preference on
Well,
that?
I would like to have that. I'm hesitant to impose on counsel, to do two things at once. But since it is fresh in your minds, fresh in our minds, and there's a likelihood I'm going to have to rule one way or the other. I mean, that is a possibility. And what I said initially about having findings of fact that's key to some actual document sites, some exhibits, that's very helpful. Otherwise, this is, even if it's only been a 2-week trial, there's a lot here. So I would like that. Normally I'd ask for that in a couple of weeks, but I'm not going to do that. I'll give you some more time. I'd say within the same 30-day period, if you could give me something.
Your Honor, we would actually request 60 days for that, and here's why. If we're going to meet and confer and have this process, we're happy to do that. But the agency does have a number of risk evaluations that are being finalized right now and being published, and the program is very taxed right now. And I think 30 days to do both post-trial briefing and have the type of conversations we need to have within the agency and with DOJ around some potential alternatives here is just going to take a little bit more time for us. And so if we want to confer in 30 days and have 60 days for post-trial briefing, or the other way around, but I don't think we can do both in 30 days.
Could we ask for 45 days, Your Honor?
Well, let me tell you that I have one very practical limitation, and that is my staff that's been working with me on this case. As you know, there's always a turnover. The last thing I want is to get findings of fact and have somebody new who's never heard this case. I don't think it'd be to your benefit or to mine. So if anything, that's going to be a priority. I'd rather give you more time to talk about the resolution. And I do need those findings of fact and conclusions of law. I can give you
from plaintiff's perspective, we could get those to you next. I mean, we could get them as soon as you want them. So obviously at the same time as EPA does, but we have no concern about getting them to you whenever you want.
I'll need them by July 27th. That gives you the weekend, but I will need those by the 27th.
Hey, can you? I'm sorry. It's not post-trial briefing. It's just an update on the.
Yeah, I don't need. I've heard you. I don't think I need any more sort of argumentation. And actually, if you could take whatever, and you'll have to change your actual findings of fact because you've already submitted but update those to what the evidence conform to. But really, it's a citation that's helpful.
Your Honor, on the briefing, plaintiffs would like to, with court's permission, submit a brief on standing, because we do believe that there's additional case law that we haven't yet addressed, and we believe we can provide the court a very helpful analysis of the evidence.
Well, that is the one issue that I was going to ask. I started asking Ms. Cohort some of those questions, and so I would like to give the parties a chance to rebrief the standing issue now that we have the record. So that I don't need 50 pages. I need maybe 10 to 15 pages at most on the standing question, because you've already briefed that to a certain extent. I'll relook at that, but yes, if you could submit briefing on standing, and you can do cross briefs on that. I don't need set to 3 briefs. You can cross brief that, let's say in 14 days. That's a legal question, right? So it shouldn't be that hard.
Right.
Largely legal question.
And with respect to systematic review, would Your Honor want any additional briefing on?
I don't need any more briefing on that. Yeah.
Your Honor, the standing brief, 14 days from today.
Yeah.
And the findings of fact, Your Honor, did you say July 27th?
Yeah.
And I don't think we actually set a date for the status conference.
And then Angie was going to give me a status conference date. Do you want more than 30 days since you have to be working on this, like 45 days
Yes.
or something? Okay.
That would be great. Thank you.
Angie, 45 days out?
Your Honor, July 30th?
Your Honor, that's not very,
Yeah, let's go a little longer than that. How about the week
Yeah.
after that?
Oh,
August 6th at 10:30.
Okay. All right.
And
Yes.
I assume, Your Honor, because we're just so good at it at this point, we can do that either via teleconference or Zoom.
Yeah, we're not highly unlikely we're having any live civil hearings for a while. So we'll do this by Zoom again. We'll
Right.
send out a notice for those. That
I might be on vacation, Your Honor, so I might be a little bit more informal place, but that's
I understand. Well, if you're going to do that, I'll take off my robe and my tie because it's been killing me. All right, so let's do that. And at this point, the record for the trial is closed. It's completed, and subject to receiving your proposed findings of fact, conclusions of law, I will await to take it under submission. But so that's the state of the record. So let me thank the parties. I know both of you have worked very hard, and this is a complicated issue, and I've found that the presentations have been informative and very helpful. Thank you.
Thank you, Your Honor. And
right.
can we thank Angie for how wonderful she was figuring out this Zoom so quickly and making everything run so incredibly smoothly?
I will join in that thanks.
Thank
You
you.
can barely see her, but I see her smiling.
You're very welcome.
Yeah, she's done a terrific job, especially this is our first time out doing this, and I think it worked well. I also want to thank our IT staff. Buzz, who you met a couple times, really was instrumental in making sure this worked. But I think this shows that the process, not ideal, but in these difficult times, at least we can still do court business. So thank you for your flexibility as well. Appreciate it.
Thank you.
Thank you, Your Honor.
Thank you.
Court is adjourned.
The recording has stopped.